You are facing one of the toughest times in history to be a landlord. Your tenants may not be paying rent because of COVID hardships, and the rules keep changing for landlords. You're probably wondering, what are your options? You'll hear the answer to this question. Can I actually evict anybody now? How do I collect those past rents? Who can help you make your payments if the rents have been reduced that much? Those questions and more will be answered for you. For over 30 years, Rene Nelson has not only been a landlord herself, but has also facilitated in the sale of hundreds of multifamily units, as well as a variety of other commercial properties through PACWEST Commercial Real Estate, of which she is the president. For more than 27 years, Brian Cox has held the hands of property owners through the legal quagmire that real estate investors are constantly faced with. Brian is not your average lawyer. He specializes in residential and commercial property management, landlord representation, foreclosure, eviction, and litigation, just to name a few. Brian has published dozens of articles and has given accredited presentations at the Rental Owners Association of Lane County. Brian Cox is our local legal expert. Thank you for joining us today.
Evie, thank you for that introduction. Brian, I'm so excited to have you on the Zoom call today. I'd like to ask you a couple of questions. Could you please quickly give the history of how no-cause evictions have changed in Oregon recently?
Thank you, Renee, and thank you, Evie, for the nice introduction. Over the course of time, and I think we have to frame this in the context of property owners or investors, how does this affect our plans? Over the course of time, we used to be able to say, hey, tenants, we want to market this property, so here's your 30-day notice, or at the end of the lease, guess what? You got to go. And that would allow us to empty the property, stage it, paint it, put lipstick on it, and sell it. We've seen a transition over time, tenant protection measures to stabilize housing that required us to give people 60-day notices if they live there more than a year. And there's also been a concurrent ability to give people notices if they live in the other side of the duplex you live in, or if they live in a mother-in-law unit. And that would be a 30-day notice or a 60-day notice after a year. Eventually, what we saw happen was the elimination of no-cause evictions after a year. So it's kind of like, and not to offend any of our viewers who maybe had a different dating relationship, but it'd be like dating where you might live together for a year before you decide to get married. It allowed that period of time, and if you had a month-to-month rental agreement, anytime throughout that 12 months, you could give them a 30-day notice, and after the 12 months, you could not evict them for no cause. With people with leases, you simply gave them notices that, hey, at the end of this year, we're not going to renew you. So now you were giving them notices telling them 30 days from now you need to move. You still could do the duplex. You could still do the mother-in-law unit in the back, your 30, 60 day, but you were limited at a year for everybody else. Then we saw an evolution that said, well, we're going to allow certain kind of exceptions for people to, landlords to be able to remove people. And now we see a House bill that proposes to remove all no-cause evictions. And so that would remove those 30-day evictions at any time during the first year. It would remove the 30-day non-renewal notice at the end of the first year lease if you were on a year lease, and it would remove that 30 or 60-day option for the other side of your duplex or the unit out back, mother-in-law unit that you maintain.
So Brian, you're referring to House Bill 2372. So if that passes, then basically what remedy would a landlord have to get rid of a tenant?
So really the remedies fall into two categories at that point. One is all the existing remedies for cause. And for cause includes non-payment, except for we're under a moratorium, so not now in parentheses. But for cause is breaking the rules, not allowing me entry when you're supposed to. And that becomes one of the strategies on marketed properties, is right into your rental agreements that they have to allow you to come show the property on proper notice, that kind of thing. But for cause, non-payment absent the moratorium, and similar types of actions like that, those all remain viable options. In addition to that, you as an owner can give that tenant a 90-day notice for 5 different reasons. There's 4 exceptions, and then there's a 5th reason that works with a lease agreement.
Okay. All right. So with House Bill 2372, under those 4 exceptions, a landlord could ask for their property, or let's call it a unit. I own an apartment complex and I want to go in and rehab a couple of the units substantially. Maybe a tenant's lived there 15, 20 years, and I want to basically go in and gut it. New appliances, brand new bathroom, new carpet, new everything. Can I still basically give my tenant a no cause notice under one of those 4 causes for a landlord now?
Generally, yes, but let me give you the exception that might fall into your example. So if I have a home, I have a duplex, and I'm going to I want to empty that side, and I qualify for one of the 4 exceptions. That's a pretty easy thing to do. I give them a 90-day notice, depending on whether I own more or less than 5 units. I pay them or I don't pay them a month's rent, and they have to move, and if they don't, I evict them. But if you have an apartment building or a multi-housing complex, there's one more factor you want to bring into play. Do I have another comparable unit to move them into? And if I don't, then the answer remains the same. I just simply give them that notice and they have to move. But if I could simply move them into another unit in order to tear out the bathroom, for example, then that's what you're going to end up having to do.
Okay. So just to recap on House Bill 2372, in my professional experience, I have had landlords who have rented to a tenant, and maybe the tenant starts to pay slow after moving in after the first month or 2, and it irritates the landlord. So in that first year, they just give them a no cause notice and say, gee, I'm sorry, but we're ending our dating relationship and you have to move as a tenant. So if House Bill 2372 passes, once a tenant moves in, then you would have to go through the proper steps of notifying the tenant that they were past due per their rental agreement, and then you'd have to basically use the 3 strikes you're out rule, correct?
That's correct, Renee. Thank you. That's kind of straining our metaphor a little bit. It becomes like an arranged marriage. You don't get to decide if you like your tenants anymore. The day they move in, you can no longer say, I don't want you here. You're left with 4 cause reasons: non-payment during non-moratorium times, behavioral issues or actions, or one of the landlord exceptions. And one of the landlord exceptions, and you talked about the 3 strikes, if you have a tenant who's under a lease, and they have a set of rules, you can give that tenant warnings 3 different times in a year. And with that 3rd warning, you also give them a 90-day notice that says, hey, guess what? You violated your lease 3 times this year. You got to go. And you never have to pay in that situation without regard to how many units you own.
Okay. All right. That makes sense. Okay. Let's talk about a tenant who is behind in rent from 2020 due to COVID hardship. And they signed the COVID hardship form in, say, April of May of 2020. So they're basically given until June 30th. let me recap that. No, I didn't say that correctly. So technically, they're given until March 31st, correct? That they have to bring their past due rent current or they face eviction?
So where we talk about the rent that tenants owe for the period of time between April 1st and December 31st, there's two different ends of when they have to pay by dates. And the first one that we knew about last year and that continues through the current moratorium is March 31st, like you referenced. That's for the tenants who you sent in a tenant information sheet and a blank form declaration of financial hardship, and they didn't return it. And in those situations, they don't get an extension on their moratorium. It also the same answer to tenants who have moved out, because if they have moved out, now really what you're doing is just foregoing collection for a while. And those same tenants, because they moved out, no longer qualify as tenants to give those declarations. And so they get till March 31st to repay. But for all the other tenants, and the other tenants in this case is either every resident, every household where you haven't sent out that information in blank form declaration. So that's one default answer. Or where they have filled out the declaration and returned it. In both those situations, their moratorium and their grace period for repayment of all the 2020 rent I referred to is pushed out to the end of June. July 1st is the first day you could take action against that group of people.
Okay, so I'm really curious, Brian, what do you think will happen July 1st? Do you think a lot of tenants will scramble and try to create repayment plans with their landlords? And I realize that's like a crystal ball for you, but what's your gut tell you?
So this is the perfect time because you're really asking me to dig deep down in my guesswork.
Yeah.
So I'll be right back. I am prepared for almost anything. And I would like to give you kind of what my crystal ball says. And for all the listeners out there who are listening to me talk, nothing about what I've said today is intended or can be used as legal advice or as investment advice, and to do otherwise would violate the SWARMI. So what do I think is going to happen? I think whether the moratorium is again extended will be highly dependent on the recovery from the pandemic, the distribution of vaccines, and the recovery of jobs, or the flow of money coming into the state from the federal government. Because a lot of that will end up being channeled to landlords. All the future tenant funds will go through the current landlord compensation fund for distribution. So it depends is my answer what I think will happen. If I had to put money on it right now, I'd see another extension. It may be our last one, but that would be my expectation. The final answer is, and I haven't seen, like Rene, I serve on a lot of these work groups that develop these legislation. My ear to the ground has not heard one talking about we're going to force repayment plans on people. But I think entering into repayment plans is a really practical, pragmatic way to deal with an issue, because I evaluate things on what's the alternative? What could I do to collect this money? And our tenants don't own their homes. They don't own very much. They don't have very much. And many of them are getting subsidy to live there. And on the practical end of day analysis from the lawyer who sits under the SWARMI hat, that's not a collectible situation. So long term, I think we're going to see more. I think we're going to see more moratorium. I think we're going to see more funds flowing into the state from the federal government. And I think we're going to continually be challenged by continually complicated changes in the law that none of my clients understand.
I would agree with that. Well, it's interesting. I saw that they rolled out that the state of Oregon rolled out $150 million relief program for landlords if the tenant signs that hardship form. But the projection is that there's 5 to 6 times that amount of landlords that are in need of that program. So even $150 million is not enough to meet the demand for the shortfall that the tenants are behind in rent.
So that's correct. And it initially started at 150,000 for the landlord fund, and an addition, 150 million for the landlord fund, and an additional 50 million funded through the tenant portal. And so that started with the 200 million total. It pretty quickly jumped up to like 238 million with additional federal funds. But one of the things that I wanted to make a point of mentioning is it's designed to be an intake funnel for all the federal funds that may release into the state. And so if the federal government, if and when they do renter relief money into the state, it'll come through the same program and it'll be distributed much the same way.
Interesting. Okay. Do you think there's a potential issue where if a tenant fills out their hardship form, turns it into the landlord, and the tenant and the landlord think, well, the landlord's going to give up 20% of the rent shortfall in exchange to get 80% compensation from the state, but then the state runs out of money, the program is underfunded, or as you probably know, it goes off of a ranking system based on the matrix that I've seen, and the smaller mom and pop owners are more likely to get the funds than the larger complexes. So I could see potentially where a tenant would think, oh, I'm just going to sign this hardship and my debt will be forgiven. But if the landlord doesn't get the money from the government, then potentially that rent is still going to be due. Do you have any thoughts on that?
Well, I think you've identified it correctly. The tenant can certainly fill out the declaration of financial hardship, and that stops the landlords from being able to pursue any remedies for the non-payment of rent or non-payment of utilities through the end of the moratorium. So for that example, for right now, till July, the landlord can't collect and can't evict. But that doesn't mean the debt goes away. The landlord really is faced with two choices. One is, do I apply to the landlord compensation fund? If the money is there and awarded, I accept 80%. If not, I'm still where I was before I applied. But if I don't want to do that, what's the alternative? I wait till after the moratorium ends, after the grace period ends, and I do my collection. And I do that because under my calculus, I believe I will get 100% of my rent. My tenants are not solvent, but I have mom and dad as guarantors and they're solvent, or other things like that. And that's what I balance. If I have tenants who I know I can't collect from, I want to get in line for that compensation fund all day long. But if I think if I'm renting to Rene and Bob Nelson, I'm not going to take 80%. I'm going to patiently wait and get that money from you. And you can see how I use that analysis. The other thing I would offer is the compensation fund is going to be awarded in monthly rounds so that it's not designed to not be depleted right away. You're correct that one of the big ranking factors is the size of the landlord, in the sense of, are you a mom and pop, are you a big institutional, and the size of your past due debt. These were all designed to be so that the big boys and girls couldn't swoop in and get all the funds, and is designed to be staged so that everybody can benefit from it.
Okay, that sounds great. I have one last question, but I just want to go back to the tenants who did not pay their rent starting April 1st through December 31st. So let's kind of play a scenario. I have a tenant that didn't pay rent in April through December 31st. They filled out the hardship form. So now they technically have until March 31st, correct?
They did, I'm sorry, they did or did not fill out?
Did not. did
Okay,
not
so
fill
yeah.
out the form.
So yes, they have till March 31st to pay back their rent. And if they're still living there in January and February and March, you can actually give them a termination notice for those months for
Okay,
non-payment.
for non-payment.
There's more to those steps, but that's the short answer.
Okay. What happens on, say, March 31st if they now fill out the COVID hardship form and turn that in? Does that basically now give them the right to go into up to June 30th, call it July 1st?
That's a good question. This is a stump the chump question.
Oh, it was not intended to. It's just, I think that there are a lot of tenants that will do that because they are still scrambling. And believe me, Brian, you and I are landlords, but we also understand there's lots of people that have lost their jobs. So this is not being a greedy landlord, because the landlords are hurting as bad as the tenants, because a lot of us have to pay a mortgage payment. We have to cover the maintenance and repair, and we're not getting that rent. So we're all in this together. But I do think that there will be tenants that didn't sign the hardship form earlier last year because they thought, oh, my landlord can't do anything to me. But when the day of reckoning comes on March 31st, I think they will sign that form to try to get it extended through June 30th.
So I'll offer you two answers to that. And if that tenant is still in residence in March and they give you that declaration in March, I think they do extend out till June.
Okay.
Now, having said that, if they moved out, if you've evicted them, or if in January, February, or March they didn't pay their rent, you gave them a 10-day notice for non-payment, gave them a declaration with that to fill out, and they didn't return it, and you filed your eviction, and they didn't return it by the first appearance of that eviction, then they're stuck with March. They can't change that answer.
Okay. Okay, that's super helpful. Okay. All right, here's the last question. What is the best thing, in your opinion, that a landlord can do to protect themselves against having a tenant skip out and leave a big balance? What's the best thing a landlord could do?
For your existing tenants, there's really nothing you're going to do. You know, you have a current security deposit, you have a current relationship, you have a current past due unpaid rent, and you have a current inability to do much of anything about that. So that is not a situation that you can really alter very much. If you have a new tenant applying, and we're going to assume for purposes of this answer that none of this has to do with the Portland area, because that gets different and more complicated. So everywhere but Portland, the answer is you can do things like, how do I make myself more secure in this situation? Do I get a bigger deposit? Do I get a cosigner? And is that cosigner liquid? Do I do other things that, do I require them to prepay a certain amount of rent? There's a lot of creative solutions to this. But ultimately, what you end up having to do is, if you move a tenant in today, you're moving a tenant in mid-moratorium. And if they pay a month's rent and stop paying, they're protected. And I'm seeing it happen. Now, I want to kind of come full circle to the other part of your question, that is people who have become sophisticated, educated, and sometimes manipulative within the existing laws. I think for the most part, people are really trying to make this work, and that's shown, or that's borne out by the average rent payment in the 75 to 80% area, higher in some areas, lower in other. So people are really trying to pay the rent they owe. Of the other people, you see a certain number of people trying to work things out. But I also definitely see people positioning themselves, people who are receiving a benefit payment that pays their housing. So the money is there, it never stopped, but they stop paying their rent and they tell you, go ahead and get it from the state because you can't collect from me. And in reality, I would tell that landlord, get it from the state because you can't touch them. And meanwhile, that tenant now has 6 or 8 months worth of rent in their pocket to do whatever else with. I've seen other people do things like that. It's a minority, but it's a substantial minority of situations, and I think it'll continue.
Interesting. Okay, we're going to put your contact information down below in the video so that people can call you if they have questions. But why don't you go ahead and give your disclosure one more time about you're not giving legal advice, you're just here on an informational basis.
Well, thank you, Renee. I appreciate that. For everybody viewing this video who thinks differently, please get your checkbook out and send a blank check to my office, signed, and put legal services on the memo. For everybody else, please understanding I'm doing a good job to help you with information, but I'm not advising you. I'm not giving you, we've not formed an attorney-client relationship, and I'm not giving you investment advice. And that's just really a good cautious lawyer way of saying you can't sue me for listening to me today.
Brian, thank you. You always make it easy to understand, common sense, and from a landlord's perspective, you are always my first resource to reach out to. I appreciate your depth and knowledge, and thank you for being here today.
Thanks, Renee. It's always nice talking to you.
Thank you. Have a good day.
Bye.